Good evening and welcome. It's so great to be able to start off the 2010-2011 Critical Insights in the Law and Law Practice series. And We Are Catholic are so proud to be hosting us. I want to thank all of you for coming tonight, and I want to especially thank Dean Miles for making this possible. Tonight, we're kicking it off with an exploration of the intersection of ethics and patent law. Our discussion was suggested by the issues addressed in Therasense v. Becton Dickinson, a case in which the Federal Circuit will be hosting an in-bank argument on November 9th. And tonight, we're anticipating the ethical ramifications of that decision. As you all know, a patent is an exclusive right conferred by the United States government to promote the progress of science and the useful arts. When that right is procured through fraud, the patent may be held unenforceable. An applicant has a duty to disclose to the Patent Office all information known to be material to patentability, otherwise known as Rule 56. Intentional failure to do so can result in the patent being held unenforceable for inequitable conduct. Tonight, we're going to look at the use of the inequitable conduct defense at the trial court level, at the appellate courts. We're going to ask about the ethical consideration of the applicant's duty of disclosure. We're going to ask what materiality means and how intent and materiality factor into the unenforceability determination. I'm now going to turn the microphone over to Professor LaBelle, and she will introduce our panelists.
Thank you, Professor Winston. Good evening, everyone. Professor Winston and I are thrilled that all of you have joined us here this evening to talk about this very important case about inequitable conduct before the Patent Office. And we are honored to have four distinguished guests with us here this evening to lead us in this discussion. So I would like to introduce the four panelists to you now. Our first panelist is Chief Judge Paul Luckern. Judge Luckern has served as an administrative law judge of the United States International Trade Commission since 1984, and Judge Luckern has served as the Chief Judge since 2008. Next to Judge Luckern, we have Professor Lisa Dolak. Professor Dolak is the Angela S. Cooney Professor of Law at Syracuse University College of Law. Professor Dolak teaches courses on patent law, internet law, and practice and procedure in federal courts. Professor Dolak's research interests include issues at the intersection of patent law and judicial procedure, patent law and the media, and patent law and ethics. Next to Professor Dolak is Mr. James Kulbowski. Mr. Kulbowski is a partner at Oblon, Spivak, McClellan, Mayer, and Neustadt, where he is a member of the Electrical Mechanical Practice Group. His practice includes all aspects of patent law, including obtaining, managing, licensing, and enforcing patents and patent portfolios. Before joining the law firm, Mr. Kulbowski was a patent examiner at the U.S. Patent and Trademark Office. And finally, Mr. Edward Polk is a partner with Foley and Lardner, where he is a member of the firm's Intellectual Property Litigation Group. Mr. Polk's practice focuses on litigation of complex patent cases in a variety of technologies. And prior to joining Foley and Lardner, Mr. Polk worked as an associate solicitor for the United States Patent and Trademark Office. So please join me in welcoming all of our panelists this afternoon. We are very excited to hear what each of our panelists has to tell us about the inequitable conduct defense and about the Therasense case. So without further ado, I would like to turn the floor over to Professor Dolak.
Thank you very, very much, Megan and Beth. I'm delighted to be here to talk about a subject of great interest to me. I have been asked to give us a little bit of background in terms of where we are and where we're headed with respect to the inequitable conduct doctrine, and I'm going to give you a few thoughts on how I think it is that we got here. We are poised, as has been said, for Federal Circuit's en banc consideration of the inequitable conduct doctrine in the Therasense case, where a patent relating to disposable blood glucose strips was held unenforceable by a split panel. The split panel affirmed the district court in January of this year. The basis for the determination of unenforceability was essentially that statements that the applicant made to the USPTO during prosecution, including in a declaration, a witness declaration, that those statements were made without the applicant disclosing to the PTO inconsistent statements that had been made earlier to the European Patent Office. The Federal Circuit upheld the district court's finding that the inconsistency was highly material and that it was made with the intent. These statements to the PTO without disclosing the contrary statements to the EPO were made with the intent to deceive the Patent Office. The Federal Circuit granted en banc consideration on April 26th. We are in the briefing stage. The Therasense brief has been filed. The briefs in support of Therasense have been filed. The briefs in support of neither party have been filed. Becton Dickinson's brief is due on October 8, and the briefs in support of BD are due the following week. The oral argument will be held on November the 9th. How we got here, I would say that many people have become quite unhappy with the doctrine. Coupled with that fact are certain what I will call externalities. Taking the first factor first, there are patent owners who have suffered the loss of valuable patent rights or who have had to endure what they regard to be baseless challenges to the enforceability of their patents. There are also a number of practitioners who are struggling with good reason to deal with their ever-expanding disclosure duties. There's been a lot of commentary decrying the current state of the inequitable conduct doctrine. The externalities that I referenced, I think, include the unprecedented Supreme Court interest in patent cases in recent years and the Federal Circuit's unsuccessful record at the Supreme Court. These factors are, I think, motivating litigants to submit not only petitions for certiorari, but petitions for rehearing en banc at the Federal Circuit. We've seen the Federal Circuit grant en banc review sua sponte, for example, in the Bilski case. So I think it's fair to say that the Federal Circuit appears to be feeling some pressure with respect to controversial doctrines, including the inequitable conduct doctrine. In any event, this particular request for en banc rehearing succeeded, and I will say I signed a brief in favor of the rehearing en banc, and not necessarily though because I'm sympathetic to the facts of this case, but I do think there is a need for reform, as I have advocated. There have been, in addition to those factors, significant doctrinal expansions in recent years. I have boiled those down into three categories, just real briefly. We've had the reaffirmation of the reasonable examiner standard for evaluating materiality. We've had an expansion in the categories of potentially material information to include things like information that is completely immaterial to substantive patentability. The poster child, of course, is the small entity misrepresentation. And we've also had the expansion of the duty to disclose co-pending applications, as well as the information that those co-pending applications contain. And the third aspect of expansion, I think, is, forgive me, I have a bit of a cold, a less rigorous, at least arguably, application of the intent prong. So here we are. The Federal Circuit has granted en banc rehearing, has identified a number of questions it has agreed to review. Just real briefly, those questions touch upon whether the materiality intent balancing framework should be modified or replaced, If so, how in particular should the standard be tied directly to fraud or unclean hands? What is the appropriate standard for fraud or unclean hands, if that's the standard? What's the proper standard for materiality? What role should the United States Patent and Trademarks Office rules play in defining materiality? Should, in particular, the standard be but for materiality? I'm sure that's something we'll talk about later. Under what circumstances is it proper to infer intent for materiality? Should the balancing inquiry be abandoned? And whether the standards for materiality and intent in other federal agency contexts or at common law shed light on the appropriate standards to be applied in the patent context. Those are obviously wide-ranging. The Federal Circuit has signaled its intent with that list of questions to reconsider virtually every aspect of the doctrine. Questions that really, I think, arguably aren't even raised by the Therasense facts themselves are included in that order. So the Federal Circuit has indicated a willingness to at least consider doing a wholesale overhaul of the doctrine. I'd like to spend my last few minutes and my last remaining voice arguing that I think the doctrine should be retained but reformed. And I will reserve whatever comments I have onto specific recommendations until my co-panelists have had a chance to speak their piece. And if there's time, I'd be happy to share with you the ways that I think the doctrine should be reformed. But why I think it should be retained, a number of reasons, but things like, first of all, there is an issue with public confidence in our patent system. And I think eliminating the inequitable conduct doctrine, for obvious reasons, could exacerbate that crisis of confidence. There's a great deal at stake in patent cases, and we all know that, but perhaps we don't spend time stopping and thinking about how much is at stake in these cases. And I would note that as far back as at least 1869, there was a decision of the Commissioner for Patents that is really the decision that lies at the origins of our current requirement for corroboration when it comes to proof of invention date. And that court, in that decision, there are reflections to the extent, the essence of which are that patent applicants might be tempted to shade facts and misrepresent facts. This is 1869. And so there was a recognition that long ago about what's at stake in patent cases and the potential incentives that causes. If it was true in 1869, I would say it's certainly true in 2010. And we've seen all of the fuss about so-called patent trolls. We know that there are all these incentives for non-disclosure that outweigh the incentives for disclosure that exist in the law. Second, I would point out clearly inequitable conduct, although rare, it certainly happens. It undoubtedly happens. We've all read the opinions. We've seen cases. And I'm not talking about opinions where you and I might read a judicial opinion and say that, well, you know, we would take a different view of those facts. I'm talking about cases where, you know, there have been forgeries of the signatures of dead inventors, where there has been wholesale fabrication of invention relating to invention dates, just outright lies with respect to test results and tests that weren't done and tests that were misrepresented. So it certainly happens, and I think everyone in the room knows that it happens. So we would need to find a way to deal with that, presumably. And I also think that the doctrine, for all of the litigation it spawns, I have argued that it no doubt also ends some litigation. Presumably in those cases in which the evidence of inequitable conduct is the most credible, the case is most likely to settle. It's a very strong driver towards settlement in that regard. I think that a purely validity-based regime is inadequate for many reasons. The quality of examination in the Patent Office, we know there are issues there. We know there are issues with workload. We know there are issues with retention of qualified examiners. Furthermore, in litigation, the thumb is clearly on the side of the scale of the patent owner with respect to validity. There's a statutory presumption of validity. There is a judge-made requirement that invalidity be proven by clear and convincing evidence. And so those factors weigh in the favor of the patent applicant or of the patent owner. And so at least until we would level the playing field in that regard, I think we would have to have something other than a pure validity-based regime. we have in the United States, as you all know, non-searchable prior art. That creates problems for the Patent Office in terms of their ability to access that kind of art. So I guess the bottom line is, maybe you could have a purely validity-based regime. You'd have to, in my view, eliminate the duty of candor. It doesn't make sense to me to have a duty of candor on the books without real mechanisms for enforcing it. And the disciplinary system is inadequate for enforcing it. For one thing, as we were talking in the back of the room before the program began, the Office of Enrollment and Discipline in the Patent Office is currently hamstrung with a very restrictive statute of limitations with respect to investigations of applicants or practitioners for violations of the duty of candor. Secondly, in a significant number of cases, the inequitable conduct is not inequitable conduct of the practitioner, it's inequitable conduct of the patent owner. And so the Office of Enrollment and Discipline doesn't have any reach over those folks. So it seems to me you'd have to eliminate the duty of candor. It seems to me you would also have to eliminate the opportunity to present affirmative evidence during prosecution in the form of declarations. I mean, that evidence would not be tested. And if it was tested in litigation, it would only be tested on a validity regime. So there would be tremendous incentive to fabricate and misrepresent evidence in particular, less so the prior art that the examiner actually can get his hands on. I think you'd have to do a better job of hiring and retaining qualified examiners and paying them better. This is something that other countries do a lot better than the United States, which is one answer to the question that may be on some of your minds, why do the rest of the world not need the inequitable conduct doctrine? That's one answer. They have oppositions in other countries. We don't currently. So I think we'd have to have opposition proceedings. And I think we would have to go so far at least as to have the presumption of validity attached solely to art that was cited by the applicant and or the examiner. And of course now the presumption of validity attaches to art that was never even before the Patent Office. It's a very interesting system. So these things I would suggest to you in time we don't have to spend on it could actually lead to more litigation than the inequitable conduct doctrine. This is America, after all, the land of the litigious. So, anyway, that's where I come out on it, and I will pause there and look forward to hearing from my fellow panelists.
Thank you, Lisa. Jim, we'd like to hear from you now.
Sure. Regarding materiality, first, inequitable conduct exists where, with deceptive intent, the applicant fails to disclose material information or misrepresents a material fact or submits false material information. So what the definition of material is a key issue in reaching the conclusion of whether or not there's inequitable conduct. And there's a scale in the courts today as to what inequitable conduct or what material really is. So I think the lowest threshold, something easily becomes material under the 1977 version of Rule 56. And what that is whether a reasonable examiner would consider something important in determining whether to allow a patent. So what would a reasonable examiner consider? Well, examiners could consider a lot of different things, and they want to see a lot of different things. So under that definition, which is fairly broad, you can easily find something material. On the other end, one of the questions which the Federal Circuit asked to be brief was, should they adopt a but-for test? And meaning, but for the omission, or but for the lack of disclosure of this information, the patent would not have issued. So it's almost like saying this is very, very important prior art. Finally, the middle grounds. You have the 1992 version of Rule 56, and that's really today's standard. And something is material under the 1992 standard when it's not cumulative and it by itself or in combination with other information establishes a prima facie case of unpatentability or refutes or is inconsistent with something that was said during the prosecution. The Federal Circuit, most of the previous decisions were under the 1977 reasonable examiner standard. Even though the cases are being litigated today, the Federal Circuit generally was looking whether the patent was prosecuted pre or post 1992 and which version of Rule 56 applied at that time. So most of the decisions are the reasonable examiner, but now the decisions are starting to come out regarding the establishes a prima facie case of unpatentability, or it refutes or is inconsistent. Should the Federal Circuit adopt the but-for test? And I think not. The issue there is it would give essentially no punitive effect to inequitable conduct and would essentially make it the same as a validity standard. If you submit the prior art and the examiner sees it and says, hey, it anticipates your claim, you're not going to get a patent. So under the but-for test, if you don't submit it, well, the court is going to have to go through an analysis and say, would the examiner have allowed this application to issue as a patent? And if the answer is no, he wouldn't have allowed it to issue as a patent. The court would conclude that it was material and therefore there would be inequitable conduct if there was the intent, but also conclude that the patent would be invalid based on the prior art. So I think the general feeling is that the Federal Circuit probably will not adopt the but-for because it's a little bit too lenient. The reasonable examiner standard, which has been used extensively in the past under the 1977 version of Rule 56, that's a little bit too broad as to what's material. So I propose that what's being used today, the 1992 amendment, which says the establishment of a prima facie case of unpatentability or refutes or is inconsistent with something that was argued, should be adopted. Now, those are the details of the three major materiality standards, but in reality, I don't think that there is a court decision which would have found inequitable conduct under one standard and not another. As an example, the Dickinson Co case looked at both the reasonable examiner test and the 1992 amendment to Rule 56 and did analysis under both and reached the same conclusion under each. So materiality is an important element to the test, but I don't know how much it really affects the decisions.
Thank you, Jim. I'll turn it over to Ed now.
Yeah, actually, that's a good ending point where you left it there, because the first thing I was going to kind of start off with my comment was certainly you have the two parts of inequitable conduct, the materiality and intent. And looking this from the eyes of a litigator, you're absolutely right. If you can't prove materiality, then probably something's wrong with your counsel there. It's not that hard to prove materiality when it comes to inequitable conduct. The fight is almost always on the intent side. That's what the hardest. That's what's always the hardest to prove. Looking at the doctrine itself, I absolutely agree with Professor Dolick there. I think it's needed. It has a place in the whole patent doctrine. One of the things I always like to say, and I've held this for a number of years now, you want to find the best prior art, go look in the inventor's files. That's where it is. Whether it actually makes it to the Patent and Trademark Office is another story, but having gone through a number of cases, that's where I say the Patent Office should make the first look, and you'll find the best prior art. And so I do think that there's a need for the doctrine. Again, the problem when it comes to dealing with intent in a litigation standpoint is that it's very rarely are you going to have that document. You know, as litigators, we spend a lot of money and time looking for that one piece of smoking gun where someone has said, aha, do not give this to the patent office. If you give it to them, they won't give us our patent. It's kind of hard finding that email. We look for it, and very rarely do you find that. I mean, I've had a case where I came close, and I had to fluff that piece of document up and say, you know, look, it's there. But it really wasn't. You try to make it look like it is, but that is what's very difficult to find that level of proof for intent. So you have to ultimately get to a point where you're making some inferences from what's in front of you. What is this? If you look at this now, we've kind of come to a point where they're somewhat, and this is pointed out in the Patent and Trademark Office in their amicus brief. It's kind of pointed out where we've come to this kind of crossroads where you have two kind of divergent lines of reasoning here. One is the, if you're looking at the facts, is an intent to deceive, the really only reasonable inference that can be drawn from the evidence. And then you get another line where they kind of look at it and they say, well, did the person know and should have known that this was material, and they can give you no credible explanation as to why they didn't disclose it. So you have these divergent lines. The problem is, and certainly you do need some clearer guidance in dealing with the intent level, because you also, even if you look at the underlying case here, the Therasense case, if you look at the underlying opinion, one of the things that the court did was really relied a lot on the credibility determinations of the court, because sometimes that's what it's going to ultimately boil down to. Again, if you have any attorney worth their salt and they've prepped that witness before they step on the stand, again, they're not going to break, I think we all get used to the Perry Mason moment. That very rarely happens at trial. But, no, I did it. I'm sorry. I really, you got me. Your questions were so tough. I got to break down and tell you I intended to deceive the PTO. It's just, I'm trying to get there one day, but I've not had that moment yet. So that's the problem where you come into, is find that level of how do you make this proof here. So if you look at some of the questions that the Patent Office, that the Federal Circuit has asked when it comes to the en banc briefing and what they're going to look at, kind of the last 4, 5, and 6 deal somewhat with the intent element. And number 4, as the professor said, what you're looking at is under what circumstances is it proper to infer intent from materiality. Well, certainly it's going to be there. You're going to have situations where you have to do that, and that again comes in a little bit your balancing test that the court currently has, which a lot of the amici are hoping to say get rid of that balancing test. But I could be wrong, but I think you need it there, because if you look at trying to make that inference, if I have a very highly relevant piece of prior art and I don't disclose it, and I have a piece of prior art that means absolutely nothing, I didn't disclose it, and if I did, it wouldn't have meant a thing. Is there motivation to disclose one and not the other? Certainly. I mean, I think you can draw some inferences from those two different types, whether one is highly material and it's not. So at some level, you got to be able to draw some inferences from that. Should the balancing inquiry, materiality, intent, should it be abandoned? I don't think so. There are people, certainly there are an awful lot probably would disagree with me on that. And there are some who are saying certainly those two should be two very separate inquiries. They should be split apart. You shouldn't confuse materiality, intent. But again, I'm looking at it from the eyes of a litigator, who you're looking at these looking at documents, looking at the file, and you know something's there. You know it's there, and you know, but again, it comes to the level of how do you prove it. And so if you're going to make the level of proof so high that you got to have that smoking gun, now your doctrine means absolutely nothing. And then the last one's, one of the questions the court asked is, what the standards of materiality and intent in federal other agency contexts, should they be looked at? And I don't know. Maybe they should, maybe they should not. But I think patent law is somewhat different. But one of the points, and this is where I'll close here, when it comes to intent, one of the, if you look at the amicus brief, one of the things that a lot of are saying is, and the Supreme Court backed up by some of the actions that they've taken over the past few cases, is that we should look at regular common law principles. If you're gonna, we've made patent law special sometimes when it shouldn't be. If you look at injunctions and the other areas that, we're to some extent, we're just like any other area of the law. So they're saying we should go back to common law principles, but one thing you want to be a little careful what you ask for. If you look at common law fraud, and I think this is brought out in, I think the Patent Office brief again, one of the elements of common law fraud is to somewhat recklessness. So you want to go back to a recklessness standard. So there's a lot of issues that I hope my fellow colleagues on the panel here will jump in on when it comes to intent. But I think that could be a nice lively debate all by itself, about an hour and a half just talking about intent.
Thank you, Ed. Judge Luckern?
All right. First of all, I want to thank Professor Winston and the Catholic University of America Columbus School of Law for inviting me to participate in this panel. consider it an honor to be here this evening. My second point at the beginning is whatever I say is my own personal views and do not represent those of the U.S. International Trade Commission, nor the views of the other 5 administrative law judges that are at the Commission. I'll start out that I subscribe to 3 premises. Number 1, I think that the defense of inequitable conduct in the courts should not be eliminated, and I base that on my own personal experience. Number 2, I think that the defense of inequitable conduct in the courts is routinely pleaded, which is very, very bad, considering the time and expense of patent litigation in the United States. My last premise, I think something should be done such that the doctrine of inequitable conduct is pleaded in the courts only when there exists in reality a genuine issue involving such a defense. Now, what can be done? I only started thinking about this topic in preparing for this panel the last few days, so unfortunately I can't give you an answer at the present time. With respect to my own personal experience, I was a patent examiner for over 4 years. Thereafter, for over 8 years, I was directly involved in filing and prosecuting patent applications and working with inventors. I believe that invalid and enforceable patents, and I think they're essential to our economy, and that they have helped to make this country what it is today. However, today in the Patent Office, there is a backlog of applications to be examined. Examiners are under tremendous pressure to finalize actions. Putting it another way, I think examiners need help, and I think that attorneys and agents filing and prosecuting applications should work with the examiners to obtain valid and enforceable patents. I think getting a patent should not be merely a license to sue. It should be getting a patent which is valid and enforceable and avoid litigation in the courts. All right, let's talk about a little bit about my personal experience. As I said, really preparing for this panel brought back a lot of memories and may reflect on it. What I'm going to do, I'm going to make reference to a case that is reported at 498 Fed Sup 28, and it was issued on August 18, 1980. It's a district court judge writing the opinion. But in any event, there's a lot of background to this case. And as the court pointed out, on September 29, 1967, the Federal Trade Commission entered a final order that Pfizer and Cyanamid had misrepresented to and withheld material information from the Patent Office in the obtaining by Pfizer of the tetracycline patent. The order of the FTC was affirmed on September 30th, 1968 by the United States Court of Appeals for the Sixth Circuit. Thereafter, well, in that opinion, I should say, the Court of Appeals stated, quote, the Commission did not undertake, now this is the Federal Trade Commission, did not undertake to pass upon the validity of the Conover patent, nor do we. So they didn't really do anything about the validity of the patent. But what happened then next? The federal government filed an action in July 15, 1969 in the District of Columbia. And the federal government alleged 3 counts. The first count, count 1, sought cancellation of the Conover patent, alleging its issuance was a result of fraud on the Patent Office. The government charged that but for Pfizer's fraudulent conduct, the Conover patent would not have issued. And they made reference, this district court judge made reference to the fact that the law is well settled, that a suit to set aside a patent for fraud can only be obtained when the testimony in respect to the fraud is clear, unequivocal, and convincing, and cannot be done upon a bare preponderance of evidence which leaves the issue in doubt. This is standard law. They went on, those who have applications pending before the Patent Office have an uncompromising duty, and I see this many times in briefs, to report to it all facts concerning possible fraud or inequitableness underlying the application and issue. And they went on with standard law here. It's all set forth in this opinion, again, which is at 498 Fed Sup 28. So what happened with respect to that case? It has a history in the sense that in around 71, it was filed in the Southern District of New York, but Judge Miles Lord got a hold of the case, and eventually, with a plurality of plaintiffs, there were many, many plaintiffs, including the U.S. government. Eventually, the case was transferred to the District of Minnesota about 1972. That's where Judge Miles Lord was sitting. It was in-rate-coordinated pretrial proceedings, et cetera, et cetera. So what happened is the Justice Department had to go out in Minneapolis, and I was one of the members of the team that went out to Minneapolis for 6 weeks for a trial. Actually, it was before 2 juries. I went out there in the fall of 1974. I spent 2 years there before 2 juries. And it was a memorable experience. And there was testimony, et cetera, et cetera, et cetera. Well, what happened then? Well, an interesting thing. And again, this is reported in a opinion. It's, let me see, it's reported, I'll give you the site here. It's 1976 WL 1305, District of Minnesota. And it issued on August 16, 1976. What did Judge Lord do? He declared a mistrial. So the government had not settled. I'll just read a few things from this opinion that he said, because I was with the government. Through the persistence and tenaciousness of the United States government and other plaintiffs, over $130 million in additional settlement monies have been paid by the defendants. These are the 5 drug companies in cases before the court. This represents almost $1 million a day for trial time. Most of this money was paid over to classes and subsequently distributed to the claimants in each individual class. The United States has helped to lead the way through its persistent discovery and tenaciousness in the production of documents, etc., for the other plaintiffs in this case. The courts have often recognized the role that the Justice Department plays in civil actions such as these. Now, why did he declare a mistrial? On page 9, he states, the publicity, length of the trial, the long delays in the introduction of extraneous evidence has created an atmosphere of prejudice which cannot be overcome by instructions or admonishments to the jury. So it was sent to Judge Rena in Philadelphia. So what happened with Judge Rena? Well, I will read what he finally put in his opinion, again, which is quoted in 498 Fed Sup 28. And really the principle which he found against the government, and the patent was not canceled, because he said there have been many other adjudications which have confirmed the basic principle that prior unrecognized co-production or use will not bar a patent on a later invention of the same product or process. But what I find very interesting in this opinion, and only having looked at it the last few days and refreshing my recollection, he quotes what the attorney said to the examiner. It was examiner Lidoff. I knew him well. He was in Division 6. He was a tough examiner. And he testified at the FTC proceedings. How that happened, I don't know, because examiners don't testify today. But he testified at the FTC proceedings, and of course the FTC had found that the patent was not good, but they couldn't do anything about it. So the government stepped in. But what Judge Rena did, he did quote what the attorneys said to the examiner in the file wrapper. But what I find interesting is that also in this district court opinion is it appears to be an attorney-client document that the attorney had sent to in-house people doing the prosecution, describing what was it. And I'll just read it. It says, the attorney, this was outside counsel, wrote in the memorandum that the examiner's rejection was obviously based on the erroneous presumption that substantial proportions of tetracycline were produced by Duggar and Niederkorn. And then the attorney also said in this internal memo, which I don't think was before the examiner, obviously they didn't put the substance of this memo before the examiner during the prosecution. He stated further that mere unrecognized trace amounts serving no useful purpose should not anticipate a claim directed to tetracycline. I really feel that if that memo, the substance of that memo, was before the examiner, when this application was being prosecuted, there never would have been spent millions and millions and millions of dollars in litigation costs, et cetera. On the other hand, the drug companies would not have lost a lot of money. So I think that it's vital that attorneys and agents prosecuting patent applications, and they know what they're prosecuting. I did it for 8 years. They're not blind. And if there's 100 references there cited by a European patent office, most of them is garbage, and there are a few that really are the jugular vein, get them before the examiner. Lay it out. What are you trying to hide? I think if they did it here, it would have started. Now, let me tell you my second experience. And I'm more directly involved in the second experience in this sense. My second experience, I make reference to a case, La Bounty Manufacturing, Inc. versus United States International Trade Commission. And I'll give you a little history on that. This is an opinion that's cited at 958 Fed 2nd 1066. It was decided on March 12, 1992. There, in that case, La Bounty filed a complaint with the ITC in 1986. I was there then, alleging a violation of the Tariff Act of 1930 as amended due to the importation and sale. You've always got to have an importation coming in to get before the ITC, of Dudley's heavy-duty mobile scratch shears that were alleged to infringe all 22 claims of the 135 patent owned by La Bounty. And Judge Nice wrote this opinion. I think she was a great judge, as you would know why, but I could proceed. In the initial phase of this case, the ITC held there was no violation of the statute because Dudley did not infringe any claim of the 135 patent. The ITC did not reach the issue of validity and enforceability of La Bounty's patent. On appeal, this court, the Federal Circuit, vacated the non-infringement finding and remanded the case for reconsideration. The remand resulted in a second determination by the ITC that there was no Section 1337 violation this time on the ground that La Bounty's 135 patent is unenforceable due to inequitable conduct during prosecution in that La Bounty intentionally withheld material prior art from the Patent and Trademark Office. Specifically, La Bounty was found to have failed to disclose certain devices denominated the, quote, MS-107, close quote, quote, Adamo Dodge, close quote, and, quote, Ace, close quote, shears, which it had placed on sale or in public use more than 1 year prior to filing the application for the 135 patent. And what's nice about this opinion, I've underlined it, but in any event, in support, the Fed Circuit had indicated that the decision of the administrative law judge, that was me, contains numerous findings which establish the commercial nature of La Bounty's activity with respect to the use of the Adamo Dodge shears by John Adamo at a Dodge plant in Michigan, as well as the absence of any objective evidence that such use was experimental. And then she even quoted me. And then later on, there was no objective evidence of record that La Bounty had told Adamo and Acme that the shear was still developmental and subject to change and experimental. And then she goes on later on with even with intent. She talks about that the on-sale devices are not cumulative to art of record, and then she goes into the business about an intent, and then she finishes accordingly. Under all the circumstances here, we hold that the administrative law judges, that's me, finding of intent is supported by substantial evidence. I'm saying this is something that examiner doesn't get wind of that. Certainly, Labonte should have gotten wind of that, or it seems to me. And I don't know. I haven't looked at the briefs many years ago. I haven't seen it. But it seems to me that they should have known something about it and got it flushed out, because obviously there were arguments on the other side here. I find it a little comical also because in the Teresa case here, I looked at it over the weekend also, and incidentally, I've got another case here. The standard of the bounty, and I make reference to a case that was reported at 2000 U.S. District Lexus 17552. And in this case, this is November 20th, 2000, the court states, in arguing that the 058 patent was material, Standick erroneously relies on a superseded standard, citing Labonte manufacturing for the United States Trade Commission, 958 Fed Second 1066. So I said to myself, gee, maybe Labonte's been overturned. It's no good here. And then it goes on that the standard, at least materiality, when Labonte issued, and I authored my initial determination, information is material where there is a substantial likelihood that a reasonable examiner would consider it important in deciding whether to allow the application to issue as a patent. And the court here says, now Rule 56 defines information as material to patentability when it is not cumulative to information already of record of being made, and established, et cetera. To me, there's a lot of gobbledygook. I mean, there's got to be something done to somehow make it more specific as to what you have to do and what persons who are prosecuting the application should do. Incidentally, in this case, they found against the defense because they said in its supplemental brief, 3M contends that the 058 patent is cumulative to other prior art, and the court agreed. Indeed, 3M has persuasively demonstrated that the other references were more pertinent and disclosed more clearly all the same elements disclosed in the 058 patent as this other reference. So they actually, there they found that the defense was no good. But what I found rather interesting, though, over the weekend is in the dissent of Judge Lynn, he states here, a final point, this is the dissent of Judge Lynn and Teresa, he says, a final point deserves brief comment. The majority invokes the familiar adage that, quote, close cases should be resolved by disclosure, quoting Labonte. And I said to myself, well, why are they quoting Labonte if it was no longer law? But apparently it still stands to the principle that they have here that if it's a close case, you should disclose it to the examiner. And sure enough, the majority opinion in Teresa does make reference to Labonte. Unfortunately, I can't tell you what should be done in the patent office as far as making people who prosecute applications be straightforward and getting not only a patent so they have a license to sue, but getting valid and enforceable patents. I didn't have time to try to work that out, Professor. Go ahead. I'm finished.
I think that Jim might be able to help us out there. Jim, do you have some comments on what a prosecutor should do?
We are faced with impossible tasks every time. I started in the patent business as an examiner in '88, and there's a lot of tough situations that we face every day. And Judge Luckern, we try really hard to comply with the duty of disclosure, but there are some very difficult issues that we face. As an example, suppose you have a patent application on something as simple as this microphone, but it's really important. You could file 10 different patent applications on one microphone and file that in 10 different countries around the world. So all of a sudden, you're prosecuting it in the U.S., and you're getting, each week you get a new search report from a different country. You have new prior art coming in. So how can we, the Patent Office in the U.S. allows one of the cases, and after the notice of allowance, you receive a search report from the Japanese Patent Office. And so you file an RCE, in order for the U.S. examiner to consider this, and then you get something from the EPO, and you get something from China, and it never ends on when you have an important invention for which there's multiple patent applications filed throughout the world. There is a never-ending stream of prior art coming in, and we are faced with this when we have the most important inventions which are filed everywhere. What do we do? How can we handle the situation where we have to essentially continually reopen prosecution? Because the duty of disclosure, according to the regulations, exists up until the time of the patent issues. So the prosecution is closed when the notice of allowance goes out. So how do we handle this difficult issue? When do we draw the line?
Actually, let me add one point to that there. When you talk about drawing the line, even looking at this, how that actually comes in and causes problems from a litigation standpoint. And again, when you talk about this duty of disclosure and intent to deceive, actually we had a recent case where we had we sued someone, had a couple patents for pending that we wanted to actually assert later in the case once they issued, but as you correctly point out, smart counsel on the other side, what did they do? As soon as we got that notice of allowance, they sent us some prior art. And now what do we have to do? Well, we can sit there and look at it. We looked at it like, okay, come on, we know why you cited that. Trying to stop this other patent from issuing so we don't add it to the case. But if we don't go and fix that, now we're going to have an equitable conduct claim alleged against us. So that's what we had to do. We had a patent that was that we certainly wanted, a follow-on patent that we wanted to certain litigation, but we couldn't. We had to withdraw it from issuance and go cite that new art. And one of the things I sent out the firm-wide emails, hey, what do we do in this situation? Look, there's no intent here. Why don't we just disclose it in the litigation? But the argument that some of my partners said, no, you can't do that, because even if you do that, you didn't give it to the patent office, so it's still going to be intent to deceive. So I'm like, hold up, I'm going to give it to the court rather than the patent office. I'm deceiving? Yeah. So we had to go and so those are some of the traps that you get into when you talk about the doctrine that needs to be fixed there. And those are real-world problems that you get into that you created that, certainly we had no intent to deceive the patent office. We're trying to get this case and move it forward, get the patent allowed so we can argue that in the case, and we've given it to the judge. But those are the real-world issues that you run into.
Now, one possible solution to this is after you do about 2 or 3 RCEs and you get tired of this, what I have done in the past is you got to let the patent issue at some time. So you let it issue, and then you file really, really similar claims. And you bring to the attention very clearly of the examiner this prior art that he didn't consider. And you say, Mr. Examiner, here's this prior art. This is something new. You should look at it carefully. You haven't seen it before in the continuation. And he's going to go ahead and he allows the claims over that prior art. He's essentially saying it's no more material than what I've already considered. I'm allowing almost the exact same claims. So you're taking away the materiality argument.
But I would still bet you're going to get an equitable conduct.
Oh, absolutely.
Absolutely. You're still going to get that lodged against you.
You were very careful to say no more material, not to say that it was not material.
I'm not unmindful of these practical issues. I want to say I'm fairly sympathetic to them. I am a patent attorney. I did do prosecution at least about half-time for about 7 years. So I've had some experience, and I've also been around litigation now for 22 years. But I would point out that, there are practical problems. What Jim did mention is that there's also, he's under cost pressure from the client. The client doesn't want to hear we have to file another RCE. These things, can get fairly costly. So, but you have to also keep in mind that if this is, as Jim suggested, a very valuable patent, then the client is walking away with an extremely valuable asset. So, I do think there is perhaps an adjustment that needs to go on in the U.S. with respect to the cost of prosecution. Filing fees have stayed extremely low, adjusted for time, over the years, and the result has been that, and this is a decision that Congress has made, not that applicants have made, but the Patent Office has been starved, and that's something that that at least some patent applicants have indicated a willingness to pay more to the patent office, at least. They may not want to pay Jim more. But again, for a very valuable patent, it might require the kind of investment that Jim's talking about in order to make sure that the art gets before the office. But there are significant practical problems, and I do think the doctrine should be reformed, and I think that there are a number of things that can be done to perhaps alleviate some of these things, and I guess I'll take advantage of having the floor to say what I think some of those are. I agree with Jim that but-for materiality is an inadequate standard, and the reasons are essentially the reasons that I said when I was saying that you could have a pure validity-based regime, and that would be inadequate. And I would just add to what Jim said and what I said that remember that but-for materiality will be necessarily evaluated in the court during the context of an inequitable conduct charge. In court, first of all, the clear and convincing evidence standard applies. And the court's claim construction will govern, at least where the information that was allegedly withheld or misrepresented bears on validity, for example, in a way that would implicate the court's claim construction. The court's claim construction will govern that determination. Those two things would be different had that information been present in the patent office. In the patent office, a preponderance standard applies. The examiner need only establish prima facie unpatentability, that it is more likely than not, in other words, that the information renders the claims unpatentable. And so there's a lower threshold there, and in the patent office, a different claim construction potentially applies. The examiners are to apply, to evaluate the relevance of information bearing on substantive patentability against the broadest reasonable claim construction. And that is designed, that is by design in our system. Our system is designed to stack essentially the situation in favor of the public interest. The policy that underlies the broadest reasonable claim construction standard is to essentially serve the public interest by carefully vetting patents before they issue. And so for those two additional reasons, a but-for standard in the courts is inadequate. It's closing the barn door after the horse has left, as far as I'm concerned. So I think the Rule 56 standard is perfectly good. It's better than, and it's not only narrower, as several judges on the Federal Circuit have acknowledged, than the reasonable examiner standard, at least in certain respects. It's also more objectively determinative. It's less vague than the reasonable examiner standard. It may not be perfect, but it's workable. It could be adopted by the Federal Circuit as Federal Circuit law in the Therasense case, or the Federal Circuit could hold that it should apply because it's the standard that governed during prosecution. That would be stopping short of adopting it as Federal Circuit rule, but simply applying it as the standard that the Patent Office vetted through the substantive rule or through the APA rulemaking process. And so anyway, I think that standard could be appropriate. I think that furthermore, with respect to categories of potentially material information, I think that as a matter of law, information that does not bear on substantive patentability should be unavailable to provide a basis for an inequitable conduct challenge. If you misrepresent your small entity status to the Patent Office, I think the Patent Office should impose a large fine on you in order to maintain your patent. So there are other ways to deal with applicants who misrepresent other information to the Patent Office. I would get rid of those kinds of things altogether, and I would confine inequitable conduct to conduct which undermines or had the potential to undermine the substantive examining function. The intent standard is the hardest of these things for me to deal with. I think, and I've continued to think about it since the Federal Circuit panel announced its decision in the Star Scientific case. I guess that was August of '08, so it's been about 2 years we've been living with that standard. The, quote, single most reasonable inference standard. I think that's a pretty good standard. It's the best one. I didn't even come up with it, but I can't come up with a better one. I will admit that in Therasense, the panel split on whether that standard was applied. I find the majority's analysis in Therasense to be much more persuasive than Judge Lynn's analysis in dissent. But everyone can read those analyses for themselves. And as I said before, I'm not terribly sympathetic to the facts and the outcome of Therasense. I think those statements were facially inconsistent, and the attorney and the office official at Abbott who signed the declaration both acknowledged that they knew about those statements when they made them. And the district court made some very careful findings with respect to intent, which the Federal Circuit majority dealt with. So I actually, when Therasense came down, I wasn't terribly troubled by the result, even though I have been arguing for a couple of years now that the doctrine should be reformed. I think the balancing should be eliminated. I think that it's okay to have high materiality be a factor in a district court. I think it's fine for a district court to infer intent from high materiality as one part of the factor. We infer intent all over the law, and district court judges do this every day, and they make fact findings regarding subjective intent, and some of that is based on drawing reasonable inferences from the evidence. And the evidence in an inequitable conduct case could include the high materiality of the withheld or misrepresented information. But that's separate, I think, from saying that after you find intent, however you find it, and after you find materiality, that you then have a third step, which is to balance them. I don't think that balancing step makes any sense. I don't think it, as a practical matter, it tends to cause problems because although they're supposed to balance one another, in real life, the only way it ever works is that high materiality, having already been contributed to a finding of intent, now gets counted again in the ultimate equitable determination of inequitable conduct, because high materiality means that the patent challenger needs to show less in the form of evidence of intent in order to get the district court to make the equitable determination of inequitable conduct. So it's problematic, that balancing step. And to take it away would not destroy the inherently equitable aspect of or character of the doctrine, because you can still have excuse me, fact findings made in a jury case, the jury, on intent and materiality, in a bench trial by the judge, and then the district court, the judge, takes those findings and makes a determination based on all the circumstances, like we do in equity, as to whether or not the conduct has risen to the level sufficient to trigger whatever the remedy is for inequitable conduct that I want to get to in a moment. And there have been cases, by the way, in which district courts have said, okay, intent has been found, materiality has been found, now it's time for me to put on my equity hat, and it is my equitable determination that although there is materiality and although there is intent, the conduct does not rise to the level that I will call inequitable conduct, triggering the remedy. And that discretion to go that way would remain as it exists now under the law. The Federal Circuit has affirmed such determinations, and it would continue to exist. Speaking of the remedy, as you know, the remedy currently is utter unenforceability of the affected patent. That does incentivize the pleading of the defense, no doubt, because it's a bet the farm, all or nothing kind of reward that's hanging out there for the successful challenger. So to the extent that's a concern, I think that we could have district courts tailor the remedy to the offense. And some of this was proposed in one iteration or the other of one of the recent patent reform bills. You could have a district court declare certain claims unenforceable. You could have the district court do other kinds of things, including awarding attorney's fees. And so there are other ways to do it other than utter unenforceability of the patent, which I think should also remain in the district court's discretion. I'm a big fan of district judges and the hard work that they do and the good and capable work that they do. And I think that they could be vested with that kind of authority. Finally, in this, if the concern is over-pleading of the inequitable conduct, first of all, I'd point out that we have the Exergen case that came down, I guess, a year ago or so, which related to the pleading and said that Federal Circuit held that that inequitable conduct allegations have to be pled with specificity. The Federal Circuit had actually held that before Exergen. What was interesting about the Exergen case is what else the Federal Circuit said there, which is that you have to plead the who, what, when, where, why, and how of inequitable conduct, adopting, I think it was the Seventh Circuit standard in that case. I haven't done an empirical study of this. My sense from reading district court cases that are trying to apply that standard in the wake of Exergen is that that standard has had some real teeth. And my sense in working with counsel in cases in which I consult is that they have been required to jump through some hoops to get inequitable conduct pled. I think that standard that test has the potential to go a long way in alleviating some of the concerns about over-pleading of this doctrine. We've got to give it a chance to see if it can work. But if the concern is over-pleading, you could have a regime where you have an automatic award of attorney's fees to successful patentees who are confronted with an inequitable conduct challenge, where that inequitable conduct challenge fails. Now, of course, accused infringers wouldn't like that very much, but if the concern is over-pleading, that's one way you could deal with it. And that would tend to certainly disincentivize the pleading of inequitable conduct in questionable cases. So those are some of my thoughts on what can be done.
I had one question to follow up on what you're saying there, because if you look at the amicus briefs, there are a number who say now that unclean hands should be kind of applied to the doctrine, and I think an example may be in one of the briefs supporting the patentee that said, well, if you should take into account that if someone's a willful infringer, they should not be able to plead the doctrine of inequitable conduct, being an equitable doctrine. Unclean hands, one who seeks equity must do equity. Therefore, if I'm a willful infringer, I cannot be successful in equitable conduct defense. What would the panel's thoughts on that?
That's a very interesting question. And unclean hands is broader than just that specific case. I mean, it's interesting there, at least before Seagate was decided by the Federal Circuit a few years ago, accused infringers were at least as unhappy about the willful infringement doctrine as patentees are about the inequitable conduct doctrine. And I think there again, Seagate has had some beneficial reining in effects. So I guess I'd want to think about that. I think that, tying one somewhat elusive doctrine to another one would certainly probably lead to more work for you, Ed, probably some more work for me. Whether it would be good for the law, I think, is questionable.
And we must put one disclaimer that none of this applies to the Eastern District of Texas. So that's
I think there would be logistical problems too, because you would have to prove infringement and then willful infringement before determining the question of
yes, you would.
inequitable conduct. So
Yep.
there would be a lot of problems with that.
I like Lisa's solution about having the losing side pay attorney's fees regarding the litigation of the inequitable conduct defense, but is that really possible in our court system?
Why not? I mean, I was proposing this as a legislative solution, perhaps. Mm-hmm. So certainly it would seem to me to be something that you could impose legislatively.
The U.S. system generally is the U.S. party, the losing party does not pay attorney's fees. We don't have the British system. Now, if you do something absolutely egregious, like you're a willful infringer, you can get triple damages or something. But is there some constitutional issue or changing our legal system so much to have the losing party, when you plead a certain count, to have those attorney's fees?
There may be. I haven't, I don't know whether, nothing occurs to me that would necessarily bar Congress from coming up with that rule, but
And certainly in other contexts, Congress has done that, so.
Equal Access to Justice Act, where if you sue government, you get your attorney's fees back. You have a very successful case against the government. But that's a government issue, and that's very specific. I don't know outside of that as well.
You raised one other issue that bothers me a little bit. All right, let me raise this one here.
I raised a lot, so if there was only one other
All right,
one,
let me
I
tell
think I
it's
did
only
pretty
one.
good.
It's only one. You mentioned the small entity status. You said, well, as far as, and this is another issue that's kind of raised in some of the briefs, how far outside of pure patentability do you go to judge the doctrine of inequitable conduct? So you gave the example of small entity, and maybe I can follow that, but give the hypothetical of, I've now done a petition to make special. I have to certify that I've done a search. I don't do a search. I just say I did one so I can get the petition granted. Should that fall in within inequitable conduct, or we just give a fine for that?
Here's what we should do with that. We should change the rules on petition to make special, and instead of being able to, and make it be like accelerated examination, instead of being able to just say, I've done a search. I mean, that's what our petition to make special rule now is like. It's like, I've done a search. Trust me, I've looked so you don't have to. It's ridiculous. If you want to make special, then you have to do the search, and you have to submit the search results to the examiner along with an explanation like you do for accelerated examination. The Patent Office is coming up with more and more ways to have all these accelerated examination. I think you just boil it down. Other than the patent prosecution highway, which makes sense in terms of using other countries' work product, if you want accelerated examination, you got to do some of the work for the Patent Office. And yes, obviously, then you're taking on perhaps some additional inequitable conduct risk, because everything you say to the Patent Office can and will be used against you in a court of law. But you're getting tremendous benefits, particularly in this environment of the enormous backlog in the starved Patent Office, right? I mean, if you want your application to be taken out of turn for whatever reason, I think you do the work of the Patent Office. You just don't tell them, I've done a search.
So one question I have is, there seems to be agreement among the panelists that the inequitable conduct doctrine needs to be reformed, and I'm wondering if you think if the Federal Circuit answers all the questions that have been posed in Therasense, which we know they may not, but if they do you think that's enough? Do you think that will adequately reform the doctrine, or is there more, for example, that Congress might do? There have been proposals, as I'm sure most of us are aware, in the various patent reform bills with respect to inequitable conduct and other issues. So I'm wondering if you think it will be enough if the Federal Circuit answers these questions in Therasense. And that's to anyone who wants to answer.
I'll be skeptical and say no. The reason I don't think it, because you're trying to regulate someone's conduct. And I guess mainly if you look at, and I look at this from the standpoint, again, it's something that Professor Dolick brought up that I definitely agree with, that I think is a problem, is the inability of the Patent and Trademark Office to actually go after individuals who've been found to have committed inequitable conduct. And I'll give you a brief kind of story of when I was in the solicitor's office, had a little time on my hand. I guess they say idle minds the devil workshop, so I was sitting there, had a little time on my hand, figured I'd look up the most recent cases of where inequitable conduct had been found for the last 5 years. Found them, pulled them up, ran down to Harry Motes. I said, why are we not prosecuting these individuals here? They got a court finding, they committed equitable conduct, why aren't we going after them? And that was the issue that you heard. There's a statute of limitations. There's a general government statute that applies to fines and penalties, which the Patent Office, which I was there, I didn't agree with, but their position is that statute of limitation applies. So if you think about patent prosecution, usually before it's years have passed since that patent now goes into litigation. And it's usually more than 5 or 6 years by the time a finding of inequitable conduct occurs, you go through the court system, final judgment of inequitable conduct. That's usually more than 5 or 6 years. So you can almost do whatever you want and you will be immune from being prosecuted from OED. So maybe I haven't putting on my prosecutor hat when I was in OED. I think until you can really put a little teeth into it where the attorneys will be fearful that they could lose their license if they engage in this conduct, until that happens, I don't think any behavior is going to be changed. And to me, again, that's part of, maybe I'm self-employment. I now represent folks who have been accused of inequitable conduct, but it was something that was really something I cared about when I was at the patent office, because I thought we should have been going after individuals. So that, to me, I think would do far more than anything they do in this case to rectify conduct of attorneys when it comes to inequitable conduct.
That provision, that limitation would be removed in the pending patent reform bill. There's a provision in the bill that would toll the statute of limitations until the patent office gets information about the inequitable conduct, and then a 5-year statute, as I recall, would begin. So that actually would change if we get a new patent reform bill, if we get the one that is pending in the Senate.
But I tend to disagree with you a little bit, Ed, that things would change if attorneys are concerned about being prosecuted by OED, and right now there's the statute of limitations, which is going to effectively run out. I don't know of any attorney who's consciously thinks, I think it's okay if I commit inequitable conduct because the statute of limitations is going to expire and they're never going to get me. We care a lot. All the prosecutors really value their registration number, and if you lose your livelihood, it's something that no attorney ever wants to be accused of, or certainly not found to have committed inequitable conduct. So I don't think changing that is going to change the behavior of any attorneys.
Certainly I don't think attorneys are sitting there thinking like, oh, is OED going to prosecute me? But if you saw actual live examples of where that happened, I think that would be where the deterrent effect would come in. And if you see someone see a case, someone or you've looked at a case where someone actually lost their reg number because they were dishonest with the patent office. And again, I think there's a small percentage of people that are dishonest with the patent office. I don't think it's a lot of attorneys. But I think, unfortunately, it tends to be those rare cases where that does happen, where, again, as the judge had brought up, where people end up spending millions and millions of dollars when they shouldn't have to if that problem was rectified at the very beginning. So I think, again, you got to have some teeth in it, and there's got to be some level of individuals' accountability, and that knowing that if I do this, something could happen based upon examples that I've seen before. So that's where I come out on it.
One of the things that's interesting, under current law, attorneys who are found by, or practitioners who are found by the courts to have engaged in inequitable conduct, they have no ability to intervene in the cases, in the appeals, and this is an issue that was an issue in the Therasense case. That's something that I think we need to think about, because as Jim pointed out, what happens as a matter of fact is that those attorneys are at least at significant risk, if not guaranteed, to lose their livelihoods as a result of a court finding, and they didn't have anyone representing their interests. They had no voice in the litigation where this is at stake. Now, if they're within the statute of limitations, either under the old law or under the law as it will change if the S515 Manager's Amendment becomes law, then of course they get the opportunity to litigate the issue of their entitlement to their license before the OED. So they have a litigation opportunity in the disciplinary phase. But that's a matter of losing your license, and as Jim pointed out, you may already have lost your livelihood, whether you get your license back or not, as a practical matter. One thing I will say that's interesting to me about the Therasense case, I haven't exhaustively studied all of the amicus briefs, but I've been struck. Have any of you been struck by how few calls there are in those amicus briefs to eliminate the doctrine of inequitable conduct? I mean, for all of the fuss about the doctrine, I'm really struck by the very, and even the part, I mean, there are very few briefs, maybe one brief that is outright calling for the elimination of the doctrine. The others, you know, to the extent they even really want to undermine it, get at it different ways. And that's interesting to me because for the last year or so, when I've spoken on inequitable conduct, I've begun many of my talks by asking for a show of hands from the audience, which generally consists of litigators and prosecuting attorneys. You know, how many of you think the doctrine should be eliminated? And every single time.
We haven't asked that here.
Well,
you slipped.
Yeah, I did. I mean, how many of you think the doctrine should be eliminated? So we have, by my count, one person in the audience who thinks it should be eliminated. I mean, that's even goes beyond the experience I've had, which is that in every case, a majority have argued that or have voted to retain the doctrine, which I just think is interesting given the concerns. So there does seem to be some view among people who live in the system that the doctrine is needed. I think that's something we should stop and think about. And you know, not that I think it's in serious jeopardy. I don't think my prediction is that one thing that won't happen in Therasense is that the Federal Circuit won't eradicate the doctrine of inequitable conduct.
One of the things you mentioned, actually, I was talking to my partner Hal Wagner on the ride over here, that he kind of mentioned the point that you did, that in the other countries you address that problem through oppositions and other proceedings. Is that a regime that we should think about as far as getting rid of inequitable conduct and address it through those means rather than what we have now?
I mean, I'm all for, I mean, a regime of oppositions like there is in the EPO. For one thing, I mean, let's acknowledge the reexamination system we have is inadequate. If for no other reason, then you're not allowed to consider any non-print prior art. We have a whole category of non-print prior art in this country that you can't get back before the Patent Office in reexamination. So again, as long as that's on the books, you should have a place to take your concerns about it or your evidence about it back to the Patent Office, other than just going into very expensive district court litigation. And of course, that's the category of prior art that is most unavailable to examiners because it can't be searched. So, I mean, I guess the internet may have helped in some ways with that because you can search for products and things like that. But before then, it was completely unsearchable. It had to fall into your lap, or you had to be in very expensive district court litigation where you had a team of 30 lawyers, all of whom were being paid $500 an hour or more, motivated to go and dig it out. So certainly I would support an opposition regime, but I don't think that alone would be enough for the reasons that I've said. I mean, the other thing that happens, as I said, in some countries is they have better retention of skilled patent examiners. And that's something that we are in a terrible position on in this country with respect to how long, how quickly examiners turn over. And I just think, there's been a lot of talk in the news today about paying teachers a professional wage. I think we ought to pay patent examiners a professional wage. That's going to take some more money into the system, into the Patent Office. And that money is going to have to come via allocation by Congress, one way or the other, presumably from the fees generated from users.
Do we have? I think we have a few minutes for questions from the audience.
I have a question from the point of view of a patent prosecutor having to do with burying a reference. If by the time you've looked at all the references cited in foreign prosecution, you cited all the references in your application, you can have 200, 300 references. Isn't there an argument that you've intentionally buried the one reference within there that's likely to be material?
Regarding burying of the references, Judge Luckern mentioned the LaBounty case, and he was saying, well, it may be overruled, I'm not sure. That's the one case where inequitable conduct was essentially found for bearing the reference, and that was overruled. That one aspect of the case was overruled by Mullins versus Textron by the Federal Circuit in 1995, and there has been at least another Federal Circuit that opinion which has said that the mere fact of submitting a material reference in a long list of references is by itself not enough to find inequitable conduct. So you have to have something more than just...
What case is that?
The Mullins versus Textron case is the one which overruled LaBounty. But the issue is that, generally speaking, it is not, bearing a reference is not a really a strong argument for inequitable conduct unless there is some reason for it. And my opinion is that if you know of a very material reference, you should try to bring it in front of the examiner and point it out, and because your goal as a prosecutor is to get a patent which is valid and enforceable, and by showing it and bringing it to the attention of everybody, you're going to make your patent that much stronger.
From the point of view as a former examiner, no examiner has time to look at 200 to 300 references. So by virtue of filing that many references, you're already bearing a complete reference, unless you say put it first, or say the examiner's attention is brought to this, in particular to this reference.
But on the other hand, you do, if that reference is cited in a European search report, the last thing you want to do as a prosecutor is make the decision of saying, I don't think it's material, I'm not going to submit it. You want to submit them all.
I mean, one of the cures to that, I mean, if you have a long list of references, you've got a search report from another country where you have 200 or 300 references that are cited in there. Well, if you cite the portion of that search report where they kind of categorize what are your X references or whatever they may be, or if there's an office action, it seems to me if you cite that, you've now complied with not only giving them all the references, but you've given something that the examiner can look at to see out of all those references which one is really important, which ones are not. Because I mean, looking from a litigator's eyes, you raise a good point, and this is certainly a whole nother topic where you see examiners where someone has put 400 references and you see those nice initials next to it where everyone's pretending that the examiner looked at it and we all know they didn't. You know, said.
Judges are unaware of that practical point of view that examiners are not.
Oh no, judges, the ones I've dealt with, if they see those checks, they're going to assume judges, jury. I mean, this is a big tactic they use in the Eastern District of Texas. You know, if you want to bring up some art, you say, it wasn't before the examiner. No, see, it's number 564 on the list. It was there. It was checked off.
But
the examiner studied that carefully.
But
and it got to the patent office. Presumption of validity.
It surprises me that the point is not raised, that examiner don't have the time.
But the judge
to look at that.
they don't let you raise that.
Because you have the presumption of administrative correctness, that if the examiner checks the box, the law is it's presumed that he did read it, and you're never going to get evidence to the contrary that he didn't. So it's in.
Yeah, and the judge will not let you come in and say, well, you know, I know that check is there, but everyone in the world knows, other than you, knows that they didn't look at that. It's not getting in. It's just not going to get in.
I still feel, though, that the inventors and the people prosecuting those applications know their inventions, and if they know that a particular piece of prior art is better than others that are cited by European Patent Office, but yet would not defeat patentability, they should point that out in their prosecution before the Patent Office, because prosecution is so important. I look at the intrinsic evidence first, claims, the specification, and what is said in the prosecution. That's intrinsic evidence. And it's so important with respect to deciding a case. Yeah, you can always hire experts. And I haven't seen yet an expert will come in, be contrary to the person who hired them. They're good. I'm not trying to say that they're not helpful, but intrinsic evidence, that's it. And be straight up with the examiner and point it out. We all know that the Patent Office is under tremendous pressure now. I won't say anything more than what I said earlier.
A recent study, and Hal wants back, a recent study suggested that examiners actually rarely rely on applicants submitted. It's a very controversial study, prior art. 13% of the prior art listed, used in the references that they looked at was applicant submitted. Only 13% of the rejections were made using applicant submitted art, despite the fact that a much higher percentage of the references were applicant submitted. And so there really is an issue with pressure being put on examiners. How?
Professor Dolak raised several very important points why she favors inequitable conduct to solve some existing problems, but some of the problems that she's mentioned can be solved in other ways. So first of all, and to me one of the most important issues, is the presumption of validity over prior art that hasn't been cited. So whether the Supreme Court grants certiorari in Microsoft versus I4I this term, or whether it does in some future case, that'll be solved. That's nonsense that they have a presumption of validity there. Secondly, examiners are underpaid. The answer is not to pay them more. They make a lot of money in absolute terms in other parts of the country. Have you ever heard of Detroit? Move most of the patent office to Detroit. There's some excellent engineering schools. People would love to work in Detroit at the patent office. We're all spoiled here. So Capos is this idiotic idea we should move part of the patent office to Silicon Valley. There is some low-rent district we could get people to. And then why is it that the rest of the world, they all study in the rest of the world our U.S. system, emulate a lot of what we do. Why is it nobody has not adopted our system of inequitable conduct? It's a warfare between applicants and the examiner. It creates distrust. And this prosecutor to my left had said, well, who's going to read 300 references? Well, that's right. You flood the patent office with hundreds of references. They might as well start searching on their own. The final point is Professor Dolak has pointed out that there's some areas that cannot be brought forward, uses and so on. But I think with the case law on what is a print publication in terms of email correspondence has broadened this out quite a bit. And the very last point is, while re-exam takes a long time, I would give the example of the same problem that was faced in Japan with post-grant review until 2000. They had 7 years. 7 years. What did they do? The Supreme Court says, in essence, you lazy bastards, to the Patent Office. And what the Patent Office did? It reallocated resources. How simple is that? We have a special dispatch mandate for re-examination, all re-examinations. Of the 400-some thousand widgets that pass the Patent Office door every year, maybe 200 or 300 are re-exams. Well, put some manpower on it and follow your statutory obligation. Then you'll get some response.
Okay, I'd like to thank everyone for joining us tonight, and I would like to especially thank our 4 wonderful panelists for a very interesting presentation. And Professor Winston and I are also extremely grateful to Dean Miles for supporting for her support with respect to both the intellectual property program generally and this event in particular. And finally, we wanted to let everyone know that we will be continuing this discussion on November 9th. We are hosting at Catholic a debriefing after the Therasense oral argument. So the oral argument will be the morning of November 9th, and then we have invited the parties to join us at Catholic for a debriefing, and the former Chief Judge of the Federal Circuit, Paul Michel, will be moderating that panel. So we invite you to join us on November 9th to continue this discussion. Thank you very much.